one contempt case is pending, Lordship, arising out of date of birth matter. Respondents have preferred LPA, Lordship. On 13/6,
mentioning के लिए outside the list, it has to be mentioned before the unmentioned.
Lordship are directed to list the case as earliest at the disposal of LPA, Lordship.
LPA has been disposed of. तो आप चीफ साहब के पास जाके मेंशन करिए कोड नंबर 1 में आउटसाइड लिस्ट है you mention it.
My lords, mentioning from the list, it is serial number 99, 100 and 101. 3 second appeals challenging the same order. Ma'am, I have filed an IA for early hearing in this matter and the CO has passed an order in favor of some third party.
It is the appeal of which year?
2019.
2019. 2009.
2019.
90. We'll see. We can't say anything.
Ma'am, it may be fixed for some time, not today.
It is already fixed, but I'm a very slow judge. I take my own time.
From the daily list, fifth case, item 15, 2nd April 26 of 2003.
नहीं ये वाला नहीं आपका मैटर है. We'll hear that. कल से चल रहा है उसको खत्म करेंगे. आपका भी करेंगे सर रुक जाइए इनका एक मैटर है खत्म.
From supply list item 2, 2nd April 78 of 1999.
You can refer to each substantial question separately.
Definitely. But I may just indicate before I proceed that Mr. Sinha would also lead me in notes with regard to one of the questions of law.
I'm not going to wait for him.
No, I'm not asking.
If he comes,
I will proceed.
We'll proceed.
Yes, we'll proceed. But first, your lordship will kindly take but the question of law, but that is with regard to readiness in willingness. Because if that is answered in my favor, everything else will follow. Lords, for this, your lordship may kindly take note of the specific relief act.
Section
16.
16C. Okay.
Yes. Yes. But section 16. Personal part to release. Specific performance of a contract cannot be enforced in favor of a person. So the language is that a specific performance of a contract cannot be enforced. It emphasizes not that cannot be enforced in favor of a person. Now A, B, C. Note what are the three categories? Note, let us see this. Yes. A is who would not be entitled to recover compensation for its breach. This is not applicable here. Who has become incapable of performing or violates any essential terms of.
It's not applicable.
Yes. Now let's see. So my emphasis was on reading that it cannot be enforced. That this is the language. It starts with this.
Yes.
Now let's see who fails to aver and prove that he has performed or has always been ready and willing to perform the essential terms of the contract which are to be performed by him other than the terms of performance of which has been prevented or waived.
Okay. Ever and prove.
Yes. So it has to be pleaded and proved by way of oral and documentary evidence to show that the plaintiff was ready and willing. And now your lordship may kindly take note.
देखिए आप ना बीच बीच में पॉज मत करिए.
हाँ.
हाँ. प्लीज कोर्ट का टाइम नहीं वेस्ट करिए. हम आपसे कुछ नहीं पूछ रहे. यू जस्ट कंटिन्यू योर आर्गुमेंट.
Yes. No, I am just trying to refer to what is the law on this aspect. And
You are referring to some judgment.
I am referring to one judgment just to show that what is the law on this subject.
Which judgment is this?
Yes. This is 2025.
देखिए प्री अमेंडमेंट का कोई जजमेंट आप दिखाइए.
हाँ.
है ना? 2025 is post amendment.
But so far as readiness and willingness is concerned,
It is not one and the same. Please. अगर आपके पास पुराना नहीं है तो मत दिखाइए. उसके बाद वाला है तो दिखाइए. We will see that. But there is a difference. प्री अमेंडमेंट एंड पोस्ट अमेंडमेंट में फर्क है. अगर प्री अमेंडमेंट का जजमेंट होगा तो हमारे लिए इजी होगा. अदरवाइज आई विल इंटरप्रेट इन माय ओन मैनर.
time goes up because I have brought all notes.
आप पहले अपने जजमेंट्स एनलिस्ट कर लीजिए.
हाँ.
पैरा के साथ.
Yes.
फर्स्ट इज
But first is 1995 volume 5 SEC,
वॉल्यूम 5 एससीसी
page 115,
115 पैरा
paragraph 5.
5. नंबर 2
Then not 2002 volume 9 SEC,
वॉल्यूम 9 एससीसी
page 582,
582
paragraph 4 and 5.
पैरा 4 and 5.
Then 2020 volume 3 SEC,
2020 वॉल्यूम 3
3 SEC, page 280.
280
Then
पैरा
not, this is para 15 to 21.
15 to 21.
Yes.
Next
Then not next is 2024 SEC online. Supreme
Online.
Court 3586,
Supreme Court 3586
para 10 to 13. Then not 2025 volume 3 SEC,
yes
page 513, paragraph 16 and 18.
yes next
Then not 2019 volume 3 SEC,
वॉल्यूम 3 एससीसी
page 704,
704 पैरा
para 7 and 8.
7 and 8.
Yes. And not two judgments not which I would like to place. I will just refer those also. 2003 11 SCC. Sorry, not 2023. 23 11 SCC. Page 775. And notes 2024 SCC online. Supreme Court 1749.
I just want to know one thing.
Yes.
You have cited as many as 10 judgments. The principle is the same.
Yes. But the
If the
principle
principle is the same, choose one judgment.
But I will.
What is the big idea of
No, no,
multiplying
no.
the judgments?
No, it is not the big idea. Therefore, I want to place two judgments out of this,
Okay.
which
Tell
has
us.
been relied on all earlier judgments.
Choose your judgments.
Yes, this is 2024.
Okay. Serial number 4.
No, no.
2024 SCC
24
online.
SCC online 1749.
Just a
Because the facts are somewhat not
Okay,
same.
fine. Other one,
2023 11 SCC 775.
these two would suffice.
These two would suffice, not?
You can place one more, 1995.
Yes, 95.
Right,
Fine.
that will be pre-amendment. Right. Let us see that.
And not
Now
one
next-
judgment passed by your lordship in first appeal. Your lordship will kindly.
You see,
Yes.
I don't cite my judgments. In my judgments, there is a reason for it. We do not know whether that judgment has
So
attained
your lordship has
finality.
relied upon the Supreme Court.
I must have relied.
Yes.
I am aware. I have done many matters
Yes.
on specific performance of contract. But my judgments, I do not want to specifically rely because we do not know whether it has attained finality. Suppose I rely on that judgment and that judgment is ultimately set aside.
But, yes.
You never know. So, and since I have relied on Supreme Court judgments, you can straight away refer
Yes.
to Supreme Court judgments.
But I only want to just inform your lordship that your
I am
lordship
aware.
judgment, yes.
Mr. Sinha also knows that I am
Yes, yes.
aware of this.
I'm aware.
So we can just refer to 1995, and anyways, you just give me my judgment also.
Yes.
This
But
is
first
second
appeal 25 of 2024.
25 of
24.
2024.
Decided
Judgment
on
dated.
2/4/2025. Okay.
ये वाला जो है ना,
हाँ.
first appeal 25 of.
We have a question.
I will do.
हाँ, चलिए. Rest काट दे.
हाँ.
ठीक.
Because I think the law is fairly well settled by
Yes.
now. What I have seen in this matter, the argument yesterday, which has been comprehensively noted by your lordships in the 5-page order, is that they are saying there is no dispute that we were ready and willing. I primarily believe because the para 7 of the WS is not categorically denied, and therefore that is their best case so far as ready. Because with respect, that may not be the correct position. My denial or no denial, this is not a question of fact. This is a fact which you have to plead and prove. There is a vague pleading that I am ready and willing, but there is no proof at all. In absence of any evidence, oral or documentary, in view of all these judgments, the suit is liable to be dismissed.
You can read PW11,
Yes.
like PW11 conclusions. He is the best person.
Correct.
So according to you, irrespective of what is the answer to other substantial question of law, but since this particular ingredient is not satisfied, therefore they are not entitled for specific performance of contract, but at the same time you see, the other substantial question of law are also very relevant.
I will answer.
So you need to answer that also, and since that it has been framed, that has to be
I
answered.
just answer why I say that the third substantial question of law if answered, then there would be no requirement to answer
No,
the
no,
first.
it will not be like this.
No.
I am making it very clear to you.
I will answer it, I'll address it, but let me just make my submission. If a lordship looks at the provision of section 19 on which they are relying, what does it say?
No, first readiness and
Right.
readiness.
I'll just
Let's
keep it
finish
short.
off this and then lie is PW11. साइड में लगा हुआ है, साइड में फ्लैग लगा हुआ है. मिला? He is the plaintiff himself.
Yes, that is 19.
Oh, 19, sorry, not 11.
That is TW.
Sorry, I just forget that. 19. Yes, please read it.
इस मुकदमा के हम वादी हैं. वाकस जमीन का प्लॉट नंबर सो एंड सो तथा होल्डिंग नंबर सो एंड सो है. ये जमीन बाजार
Location.
हाँ लोकेशन है, गली पट्टी में है. वो गोला रोड से सटे जमीन है. ये होल्डिंग पहले की ये होल्डिंग पहले डीबी सलीमन का था. वो
ये सब में कोई डिस्प्यूट नहीं है. ये पैरा नंबर 3.
खरीदने के पहले होल्डिंग से उत्तरी भाग का
These are the previous purchases.
previous purchases.
Now, 4 is also ये 4 पढ़िए.
जो हमारे
This is about the previous agreement which you could
previous
not
agreement, in fact,
satisfy.
we wanted to show that previous agreement. I'll come to that.
Which he could not comply.
Yes, but I'll come back and answer that. First, 79 agreement. It was actually 10. Previous is a para 10.
Para 5.
Para 5.
Para 4 is previous agreement which he could not comply.
इसके बाद
ये वाला. Para 5 is the present
इसके
agreement.
बाद 1970 साल में 5वां महीना में 59
100 रुपए.
25
59
फीट. Sorry, give me something description.
Description of
25 फीट जमीन का बातचीत हुई. हमसे हिस्सा में
2 साल के अंदर रुपया वापस कर देंगे. ये एक्सचेंज का है.
that is one another. So that was para 10 is probably this.
Let's see para 10.
Para इसके बाद जमीन August 1979. August 1979 is para 10. ये जो agreement हमने
Yes, please.
अगस्त 1979 में जो अग्रीमेंट हमने लिया उसका खर्चा देने के वास्ते तैयार
करार तैयार
करा।
अभी भी हम तैयार हैं।
अभी हम तैयार हैं।
अभी भी हम तैयार हैं। तगादा भी बार बार हमने केवाला करने के लिए किया, जिसके लिए
हमने बीबी सलीमन से वकालतन नोटिस भी दिया। इस नोटिस का जवाब नहीं आया। अपने बचाव में बात में संबंधित सभी कागजात हमने न्यायालय में दाखिल किया है, जिसका ये कहना गलत है कि हमने मुकदमा हमारा दावा सही नहीं है। बेसिकली सजेशन है सर। So this is the only evidence and blind that हम तैयार हैं। Please mirrors with paragraph 7 of the plain. This is the only pleading and evidence. But that according to us is not sufficient in the light of the law laid down by Supreme Court. There has to be some material to show that you had the means to pay or you would have otherwise capable of arranging. Mere statement that I was and I am willing to comply is not sufficient. That is what all इसके अलावा कुछ नहीं।
अभी भी हम तैयार हैं।
That's what it's a statement.
Ready. Basically, I am ready.
Ready. Willingness is something more. Readiness and willingness are two different concepts. Your lordships are there. I may be ready and but willingness has to be proved. Now, if this is the evidence, if your lordship
बार-बार हम बोल रहे हैं और
तगादा कर, तो हम तगादा कर रहे हैं, but हम ready.
उन्होंने नोटिस भी दिया, लेकिन जवाब नहीं दिया।
ठीक है। But the point is that you will have to prove in court that you had the means. Merely by saying that I am ready and willing to purchase is not sufficient. The willingness has to be proved otherwise.
Is there any cross-examination on this?
Not.
There is no cross-examination on this. Have you checked it?
I don't think so. Because, to be very, I'll just doubly check, but I don't think there's any cross. Now, just
एक second. Para number 21. भाई हंसराज कन्वेंस का बात है 21।
ये तो पुराना एग्रीमेंट है।
हाँ पुराना एग्रीमेंट। Just a moment, let me just check. Give me 1 minute.
Yes.
There is no cross-examination of this witness. Any further cross-examination?
Except that the suggestion was used.
Which is the suggestion?
And that character only कहना गलत है, you know, how that suggestion propped up in examination in chief. गलत है कि हमने बोलना
पैरा 10
पैराटेन में लास्ट में है सजेशन है, ये कहना गलत है कि हमने मुकदमा शी दिखाया है, हमारा दावा सही है। So can I? But this is not sufficient. Why I tell you? Why I say? If your lordship takes the your lordship have cited this 2023 judgment, 2023-11 judgment, 2023-11 SCC 775, para 33. 311 है.
Right.
2311. Though there are other paragraphs, but kindly come to para 33.
That's right.
Para 33. What I am trying to say in Acharya, third line, not in Acharya Swami Ganesh Dasji versus so and so, cited by so and so. This court said that there was a difference between readiness and willingness to perform. While readiness means capacity of the plaintiff to perform the contract, which would include his financial position, willingness relates to conduct of the plaintiff. So the first part, his financial capacity, is not pleaded that I have or I will arrange. That is what the Supreme Court said. That there are two things you can say so far as finance is concerned. That see here, look here, this is my bank, this is the amount I had, and I am maintaining that. Or I don't have the money, my father, my brother are ready. They will step and say, yes, I have the account, I will. So that readiness has not been proved at all.
What about the other judgment?
Yes, this next judgment is 2024. 95 is 95 para 5.
Yes.
Kindly come. It is settled law that remedy for specific performance is an equitable remedy and is in the discretion of the court. While discretion requires to be exercised according to the settled principles of law and not arbitrarily as enumerated under Section 20 of the Specific Relief Act, under Section 20, the court is not bound to grant relief just because there is a valid agreement of sale. Section 16C envisages that the plaintiff must plead and prove that he had performed or has been ready and willing to perform the essential terms of the contract, which are to be performed by him, other than those terms of performance which have been prevented or waived by the defendant. The continuous readiness and willingness on the part of the plaintiff is a condition precedent to grant relief of specific performance. The circumstance is material and relevant and is required to be considered by the court while granting or refusing to grant the relief. If a plaintiff fails to either aver or prove the same, he must fail to adjudge whether the plaintiff is ready and willing to perform his part of the contract. The court must take into consideration the conduct of the plaintiff prior and subsequent to the filing of the suit, along with other attending circumstances. Now kindly note, the amount of consideration which he has to pay to the defendant must be necessity to be proved to be available. This is what I just wanted to show. This is not there. And the last judgment is 2024. This is again a compendium of all the judgments. Now kindly come to the findings merits of this judgment, which are at para 22 minutes. All the judgments have been para 22 minutes.
Yes.
Having considered the submissions or analysis is as follows. Relief for specific performance is a discretionary relief. As such, courts, while exercising power to grant specific performance, need to be extra careful and cautious in dealing with the pleadings and the evidence in particular led by the plaintiff. The plaintiff have to stand on their own legs to establish that they have made out a case for grant of relief or specific performance of contract. The Act 1963 provides that certain checks and balances which must be fulfilled and established by the plaintiff before they can become entitled for such relief. The pleadings in a suit for specific performance have to be very direct, specific and accurate. suit for specific performance based on bald and vague pleadings must necessarily be rejected. Section 16C of the 1963 Act requires readiness
That's,
and
this much
willingness.
is sufficient.
Now, one more fact I wanted to prove. Now, your lordships have consistently held that it is an equitable relief under Section 20. Now, the trial court invokes equity by saying what? It says that the
It is
houses
sandwiched.
sandwiched. That, according to me, is a misdirection because equity must.
No, we'll come to that later. Let's complete
So, but
this
this
readiness and willingness.
are.
And where is my judgment?
Latest one.
Your lordship judgment.
ये latest one है 2025.
बंद कर देता हूँ।
हाँ
तो तुम
ये उसका पैराग्राफ 18 फ्लैग मारते हैं.
Para number?
Para 18 notes. I've just put a flag.
1-8?
Yes, 1. Same paragraph.
Para 16. अच्छा तो there yes was para 18 year old Kamal Kumar versus Premlata Joshi. Whereas what is relevant is I will not. Here, para 18, a judgment of 2019 in Kamal Kumar versus Premlata Joshi is extracted. Now, your lordship will see 7 there's 7 to 7.1. There are conditions. Kindly, for a moment, keep that. Kindly come to 8. In our opinion, therefore,
This
yes,
one?
para 18 of this judgment, there is another judgment quoted. Kamal Kumar.
Kamal Kumar. Yes.
Kamal Kumar, para 8.
Yes, para 8.
In our opinion, the above mentioned questions are part of the statutory requirements. See section so and so, so and so, so and so. These requirements have to be properly pleaded by the parties in the respective pleadings and proved with the aid of evidence in accordance with law. It is only then the court is entitled to exercise its discretion and accordingly grant or refuse the relief of specific performance depending upon the case made out by the parties on facts. So there are preconditions. Merely saying is not sufficient.
I just want to know, Mr. Sinha, by virtue of 2018 amendment, the plead term has been omitted.
Yes.
Only proof remains.
Proof to me is important.
Yes.
So
Why?
I
What
think
is the big idea of doing
there is
this?
no difference. I will say that there will not be a difference because plea may appear to be superfluous. Proof without pleading is
At
inherent.
best, the law continues to be the
The
same.
same that you can't prove what you have not pleaded.
That's right.
So if I write proof, then
It is
has to-
something like if you say that it is there in my bank account, then the other side should have an opportunity to say that you don't have a bank account.
Correct. Correct. Yes, you do not have it or you misused. Now what had happened? Conduct here is relevant. He has purchased 2 prior properties. There, my lords, he says that I ran out of funds at one point.
Previously.
Previously. That's what I'm saying. So it is not a person that he's a man of means who has all along conduct, prior and subsequent, both are important. That where I have seen that he at one point of time delayed it, he ran out of funds, his funds ran, I will then not wait for him. So that's what I'm trying to say. That conduct also shows that he has.
That particular conduct reveals that he may not be in a position to
Correct.
pay.
And
And
all
therefore
along,
the onus was all the more on him to say that this money is lying.
with me. Correct.
Did he deposit this amount before the court when the specific relief was granted?
No.
Trial court?
No. There's no money deposit.
Have you deposited that money in the court?
This is your lordship judgment.
Advisor? This one you have given me, FA 25.
Yes.
I have got that.
Go ahead.
This has attained finality
I have to check that.
because there is a direction to refund also. I was just wondering.
But the judgments, one or two judgments, your lordships have 95, your lordships have noted
No,
that.
it's immaterial. You see, I told you, as a matter of principle, because we do not know which judgment will go what way, and
Correct.
these are the matters which are we are getting judgments from the Supreme Court about the second appeal. So they will go.
But the, yes.
It is these land disputes, these matters will certainly settle, not settle prior to Supreme Court. High stakes are there. Maybe old matters, but high stakes are there otherwise.
Yes. So that is
Now,
the,
at best, you can further say that at this stage, once you are in possession, whether this court would still consider granting specific.
And at the rate which was fixed in the year 1979. I wanted to say, but because the rate there are judgment which says that no, then you have to meet up. But that may not be relevant because otherwise he has failed.
What happens in a situation where the specific performance is granted, in spite of the subsequent sale, then the person who has bought the property during the pendency, what happens to the consideration paid by him?
But that will be a subject matter between the
Of refund.
Between the vendor and the vendee.
And a separate suit has to be filed.
Actually, what will happen is very clear. If I fall within 19B minutes, then I have purchased at my own risk.
That's right.
So therefore, the court
Let
will
me
not.
capture your argument. On the third substantial question of law, the learned counsel for the respondents has submitted that, has referred to section 16 within bracket C of the Specific Relief Act to submit that there is a personal bar to grant of relief. And a person seeking specific performance of contract had to not only ever but also prove with respect to readiness and willingness to perform his part of the contract. The term readiness and willingness has two different connotations, and a bald statement of readiness and willingness in the plaint and a bald statement of readiness and willingness in the evidence of the plaintiff is not sufficient. The capacity to pay was also required to be demonstrated, and the availability of to pay, availability of the amount was also required to be demonstrated. He submits that there is neither any pleading nor any proof with regard to availability of balance consideration amount. The total consideration amount, by taking into consideration the property, the total consideration amount was how much? 25.
Consideration amount was
40,000.
40,000, out of which advance of rupees 1,000 was only paid. The learned counsel has also submitted that the conduct of the plaintiff is also required to be taken into consideration, inasmuch as there was a previous agreement with respect to the same property, but on account of inability on the part of the plaintiff to give the amount, the same was not taken to a logical end, and subsequently another agreement was entered into which is involved in the present case. The learned counsel has referred to the judgments passed by following judgments passed by the Honorable Supreme Court: 1995 5 SCC 115, bracket 2023 bracket close 11 SCC 775, 2024 SCC online, इसका पैरा 33, जस्ट इसको ऐसे लिख देना, ठीक है. 1995 5 SCC 115 para 5, then bracket 2023 bracket close 11 SCC 775 para 33, then 2024 SCC online 1749 para 22, and judgment passed in civil appeal number 3015 of 2013 with civil appeal number 3016 of 2013 dated 21st of November 2024, para number 18.
That's also reported in SCC on
25
This is equivalent to 25
3 SCC 513.
3 SCC 513 and corresponding para,
Parasite.
and paragraph number is the same. Right. The learned counsel has submitted that vague pleadings are no pleadings in the eyes of law so far as the readiness and willingness to perform the part of the contract is concerned. What about the other two substantial
Yes.
question of law?
Now kindly come to section 19.
Section 19.
Yes, so the specific relief act. Why I say not that it was amount to putting the cart before the horse is for this reason. What does section 19 say is, except as otherwise provided by this chapter, the specific performance of a contract may be enforced against B. Any other person claiming under him by a title arising subsequently to the contract, except a transferee for a value who has paid his money in good faith and without notice to the original. So it's a question is once the suit is decreed, it will be enforced. All these people will be binding. So if your lordship is not satisfied with question number C, then according to me, question of enforcement does not
You
arise.
see, that has a very important bearing because in this particular case, the installments of payment,
5 installments.
Five
Now I have an answer to
installments,
that. The Madras High Court
and
judgment.
one of them, and as it appears from the
One of them is
record,
subsequent to the suit also.
after coming to know about the agreement, that payment was made.
Yes.
So whether this entire amount is to be paid without in good faith or part amount has to be paid in good faith is something which
Now
is
can I
required
ask
to be
answer?
seen.
Yes. Now we are dealing with a situation where there is an execution of a sale deal. 19B says that transferee who has paid the money. This was interpreted by the Madras High Court in 68 to say that paid means the entire amount has to be. With respect to why the Madras High Court may not be correct is in view of the definition of sale under section 54.
So that is a reason which has been taken by the learned first appellate.
That's what. The Madras High Court does not
The
consider.
sale stands concluded.
Yes.
No, therefore, you see, the term sale has not been mentioned,
Correct.
and amount paid is also equally mentioned.
Amount paid.
The reason being, as I see it, the reason being that suppose one enters into a sale deed. In this case,
Very well.
pay a consideration amount of 1,000 only, right? And rest is all deferred payment.
And then with the section whether I will be.
Yes, because here they also paid 1,000. The amount remaining unpaid, you say readiness and willingness is not there, and you sell it to somebody else whose readiness and willingness is also not there at the time of making.
Absolutely. Now can I answer this? Your lordship is right. So therefore, what is important is not payment part or full. What is important is bona fide. Now, if my lords, because it is permitted in law, sale is paid, consideration paid, part paid, promised to be.
That's
Now, if the entire transaction is not tainted with malice, my lords, then it has to be acknowledged, and therefore to read that paid here as the Madras entire amount is reading into a statute which is not there. We have to read two statutes in a manner which will harm.
we have to read payment in good faith.
Good faith. That's what is important. Good faith is important. What is important is part payment in good faith. I execute a sale deal.
It doesn't refer to part payment.
Part payment. That's the error in Madras.
You see, I wish to interpret in the manner that the entire payment has to be made in good faith. So far as your readiness, I'm very
No,
very
you're
clear
absolutely
on.
right.
I'm absolutely vocal. Readiness and willingness, I have my doubts that they may not succeed, right?
Correct.
And that is why when he insisted that this point has to be there, I agreed that yes, that is
It's a
required
very
to
good
be
question
answered.
of law. Members. My submissions is that I completely agree to the bow down. to
Let's
your
have a
responsibility.
law for the state of Jharkhand
Yes, yes, ma'am.
that the entire payment is to be made.
Yes.
Because this is
The
something
entire payment, whether in tranches,
good faith.
Tranches or it's
No,
one
it
go-
is immaterial.
It is. Good faith is important.
Good faith is
Yes, and good faith is a question of law which will depend on the facts of each case.
certainly.
So one has to now prove, my lords, according to me, to make me bound by a subsequent purchaser bound. In a case of this nature, there has to be a pleading of that it was paid in bad faith, and then that also the
This is that pleadings are there. Those pleadings are there. Those evidences are there. The findings are also
no,
there.
but the
This
facts are there.
argument was always there.
Correct.
It
But-
is not that something new has come up.
No.
It was a mistake of the council, I must say, that they did not raise this point at the time of framing of question of law.
Can I answer? The facts are there. Now, merely by saying that this is in bad faith will not make it bad faith. Now, how is a bona fide proved? Bona fide, my lords, you will allege it is not bona fide, it is mana fide. Then you will have to say why it is mana.
कोई तो जजमेंट सुप्रीम कोर्ट जाना चाहिए ना.
हम लोग कह रहे जाए नहीं जाए कोई डिस्कशन होना चाहिए. कभी सर्च करेंगे तो आएगा झारखंड टाइप का अभी आता है.
I do
ऐसा
not
नहीं.
know.
नहीं, हम तो जनरली कह रहे हैं. अनफॉर्चुनेटली उतना नहीं मिलता हम लोग को इम्पोर्टेंस है हम लोग का ठीक है.
आप अपने को इम्पोर्टेंस देते ही कहाँ हैं?
नहीं, हम तो अपने आप को इम्पोर्टेंस दे बाहर. आई मेक श्योर कि बाहर का लॉयर के सामने अपने आप को
बाहर के लॉयर के सामने नहीं, अपने ही हम लोग जो चीज डिसाइड कर लेते हैं, आप दूसरा हाई कोर्ट का जजमेंट दिखाते हैं, हमारे डिसीजंस आप साइट ही नहीं करते. Sometimes I have to look for that I have already decided. Counsel says I am not aware that you have already decided, so I don't have
So
anything to
this
say.
is a problem of internet. Now we don't look up books. No one reads JLJ, no one reads SCC. It's all Google now. So whatever comes first, everyone wants to go to Supreme Court. And as I said, we are not reflected well on the internet.
And at least personally, I don't look through that my judgments are reported, not reported. I don't bother about it. And why should we?
So today, it's all on.
No, many of the judgments I find that not available on search in the internet also. It is not available. Basically, it is for the counsels to consider. Suppose they want some reporting, then it is for them to ensure that it is reported. Why should we bother about reporting our judgments? Why we are not concerned about it? That is not none of our problem. Because many of the judgments, particularly in taxation, I find, because many judgments I've given, even in arbitration, I've given many judgments. Many of them, they do not reflect, and I have to hunt for it whenever I need it. So I have created a Google link for all my judgments. I have it.
No, that's not.
So this is happening anyways. That hyperlink through our internet, I do not know. Intranet, yes.
So
That we have created, such that any judgment is available.
And is it categorized?
Yes, that is the job of my law researchers.
That's
They do it.
It has to be, or else there's no point. In fact, that's what I feel, and I would want to make this suggestion to the High Court itself, that in a High Court, whenever the matter, at least in LP, the High Court has the record which writ court order has been checked. They have to have in the search the link to the LP, because at times we don't know what happened to the LP.
Yes.
And if it is now, because ultimately Supreme Court also comes back, if not immediately in a month, they must make sure that it is tagged in the website when we search for any case that it went to Supreme Court. This is the connected order.
You should suggest this kind of things to the High Court. And it is extremely important because we have inconsistent judgments.
We have.
Different courts may have a different view, and rightly so. 226 is, you can have a different view.
But we must be aware of the views.
So we are not being made aware of the views. Still, respondents, they are not concerned, right? Petitioners, why will they cite a judgment which is against them, not expected of them?
No, that is
like you have seen compassionate appointment.
Oh, there is.
There are many subjects. Regularization. There are absolutely views are poles apart. It varies from one bench to another, and this leads to a problem.
There are various judgments on same issue, and what it is creating is it is creating utter confusion in our minds, in the minds of the litigant. What exactly we are looking at, we don't know. We can find two judgments.
It leads to some kind of speculation.
There's a
speculation, bench hunting. These things are there. Of course, it is there. Let's take it. This is how it is functioning. So
there's a judgment of the Supreme Court which says legal certainty is a rule of law, and we don't have legal certainty. That means that there has to be consistency in the views. I hope these things get better.
So this particular aspect, I want to.
Yes, Your Lordship, this is an interesting point. This we don't find judgments on this.
We have not found one also.
Yes.
I tried
so
to find out.
I think the true test, and the only difference I can point out, the only error I can point out here is that something has been read into the statute which is not provided by the statute. And why I say that this is not an acceptable view, because once we are dealing with a subsale, then the Transfer of Property Act comes into play, and if it is permitted more, that deferred payment will be there. But the true test therefore is good faith.
With respect to the second substantial question of law, the Learned Counsel for the respondents has submitted that Section 19 within bracket B has to be interpreted in a manner, has to be interpreted taking into account that execution of a registered sale deed permits payment of consideration at a later point of time.
It says, you know, it's sale section 54, where price is paid or promised or part paid or part promised.
The Learned Counsel has referred to section 54 of Transfer of Property Act and has submitted that the price of the property can be paid, part paid, or
Promised or part promised.
promised or part promised. The Learned Counsel submits that the moment the deed is registered, the sale is concluded, irrespective of the time of payment of consideration. The Learned Counsel has further submitted that so far as payment of money in good faith is concerned, the same would essentially depend upon the facts and circumstances of a case, and merely because there is a deferred payment of part consideration, the same by itself will not take away good faith from the side of the person who has purchased the suit premises without prior knowledge of the agreement of
Yes,
sale.
that is also important. And without notice of the original. Once it is without notice, then it is obviously my faith does not become a. But the law is also that as a purchaser, you are a caveat emptor. You must do your due diligence.
That's
So in the Madras judgment, the difference there was factually is that the notice of previous sale was brought to the notice of the.
The Learned Counsel has distinguished the judgment relied upon by the appellant passed by Honorable Madras High Court
In the case of Sinna Ponu.
in the case of
Sinna Ponu.
Ponu Supra, and has submitted that in the said case, prior to the sale,
Sale.
by virtue of notice,
Notice.
the prior agreement was within the knowledge
Yes.
of the purchaser of the property after the agreement of sale.
Correct.
That's all.
That is.
Yes.
Though section 19 restrictions, will decide, but the issues of enforcement. So that is a consideration in the event the suit is decreed, not
See,
otherwise.
we have to take care of whenever there is a discretion in connection with interpretation of this section. This problem would, I'm sure it must be coming up
Yes,
again
yes.
and again.
Yes.
So let's crystallize it in whatever manner, and if the parties are aggrieved, let there be a judgment of the Supreme Court.
Absolutely. I'm not
Because
that. I'm saying
our job is not only to decide the question of law, but also to crystallize it such that it becomes a guide for the state for the time being.
I'm only saying your lordship will also make sure that when your lordship decides this issue, that this will only come into play at the time enforcement of the decree. This is not a relevant consideration for deciding the suit for specific purposes. This is an enforcement. So that one line, because then in what will happen in all cases, this will become an issue. It has to be an issue, will be decided, but the relevance is enforcement stage. Against, to make me bound by the judgment. I'll be bound. What will happen is, if your lordship holds against me, I'll be bound by this judgment and I cannot claim any equity that now I am in possession, I have paid the price. No. I will be bound by the judgment.
The Learned Counsel has also submitted that so far as applicability of section 19 in bracket C is concerned, the same is to be tested at the time of enforcement of the specific performance of contract. That's it.
Must one more point on the
Anything else?
yes, but on the sandwiching of the plot, your lordships have noted in yesterday's
Yes, I
order. The only thing which my friend wants us to, this was exhibited. This map is exhibited. From the map itself, what can be seen is that this is the purchase. It is cannot be said to be a sandwich. Yes, it is in between, but they have ingress and egress from both sides. Independent ingress and egress. So therefore, the consideration of the trial court of
ने
equity.
वो मैप देख के ऐसे नहीं करेंगे. You have to tell us.
Injunction किया है. But that
Correct.
But I think that point is actually not of much saving.
हाँ बताइए क्या
Sir, I've noted the arguments advanced
Up.
by the senior.
adjournment नहीं होगा please do. No ways. What do you mean? Where is your counsel?
only being Rahul Gupta
क्या
sir
आप
is
लोग
not
करते
available
हैं?
today. He has requested to post this matter for Monday.
This is absolutely
I've
miserable.
noted
I feel miserable, you know.
It will only take 15 minutes.
15 minutes का क्या मतलब है? हम इसको लेके बैठे रहेंगे? You think that this will go in my memory?
I'm just making a prayer to post this matter for Monday so that it could be decided. I've noted and so far the
नोटेड क्या?
issue-
नोट करके जजमेंट भी लिख के लेके आइए.
I'm not on that.
क्या नोट? Why you should be on that also. अभी तो एज ए लॉयर आपको समझ आ गया कहाँ क्या जा रहा है. और एक नहीं कई जजमेंट हम डिसाइड किए, इसीलिए हम उनका सेक्शन 16 का इसीलिए हम इशू करेंगे. बिकॉज आई एम कॉन्शियस ऑफ दिस फैक्ट. ऐसे तो जजमेंट मेरा गड़बड़ हो जाएगा ना. आई विल नॉट लीव ओपन एंडेड जजमेंट्स. ऐसा तो नहीं कर सकते ना.
So the second leg of argument is concerned in respect of section 19B.
देखिए उससे हम बहुत सेटिस्फाइड नहीं हैं, इसीलिए आप उसका आई एम
Good faith
सेटिस्फाइड
नहीं है because DW का para 73 में he has noted that there is a
डोंट
dispute.
रिपीट इट. आपका
No,
हर एक आर्गुमेंट आपका पूरा इन वर्बेटम नोटेड.
Primarily so far issue of readiness and willingness is concerned. I would only submit that
कोई भी
that
एविडेंस है
remains a-
पूरे रिकॉर्ड में, कोई एविडेंस है रिगार्डिंग अवेलेबिलिटी ऑफ फंड.
Manan,
वन वर्ड.
I bow down my word, that is not
शुड आई रिकॉर्ड इट?
there.
व्हाई नॉट? अरे भाई आपसे सवाल पूछ रहे हैं, आप जवाब दे रहे हैं और बोलते हैं इसको रिकॉर्ड मत करिए.
Manan, then in that case I may be permitted this opportunity to give a reply that so far PW19 is concerned, he has not been examined so far capacity to pay.
It was his
units.
duty to ever and prove.
Manan, he was not cross-examined on that point.
Need not be. This is what they are saying.
The-
You have to
The plaintiff
plead
has
and
pleaded.
prove the onus is absolutely on the plaintiff.
But there is no denial to that. Order 8, Rule 5 says that there should be a specific denial. Section 58 of Evidence Act says if there is no denial, it would be deemed to be proved. So in that regard, my lord, if there is no cross-examination, my stand is clear.
This is your stand. Conclude कर लें हम.
और pray कर रहे थे कि इसको मत को सिर्फ रख दीजिए राहुल गुप्ता सर.
Conceptually, let us clear one thing. I will only cross-examine someone on a particular point if I am satisfied that you are able to shift the burden on me. I will not. By cross-examining, I will weaken my case. What he has not said, he will say in my cross-examination.
आपके जो सीनियर है वो भी आउट ऑफ स्टेशन चले गए.
On legs, Honorable Court 16.
ये ना इन द मिड्स ऑफ द प्रोसीडिंग द सेकंड अपील में ऑन लेग्स हो जाते हैं ना, ये सही नहीं है. ओके, इट इज नॉट प्रॉपर. आज के अपीयरेंस में उनका अपीयरेंस मत लिखिए. ही इज नॉट देयर. डोंट रिकॉर्ड हिज अपीयरेंस. The learned counsel for the respondents has submitted that. Nay, upon a query of this court, the learned counsel for the respondents has submitted that he has not been able to find out any statement, oral or documentary, in the records with regard to availability of the balance consideration amount of rupees 39,000. 39,000, as admittedly only 1,000 in advance was paid, and previously also the agreement failed because of non-availability of the balance consideration amount with the plaintiff.
Was he apparent?
Yes, appellant, yes.
Respondent.
Achha, respondent nahi appellant. The learned counsel for the appellant has further submitted that it was for the the learned counsel submits that adequate pleading and oral evidence was made on behalf of the plaintiff with regard to readiness and willingness, but in absence of any cross-examination on this point, the requirement of law stood satisfied. However, he submits that Mr. Rahul Gupta and also Mr. R.N. Sahai, senior advocate, would advance their argument by way of rejoinder to the arguments advanced by the respondents on Monday. Post on Monday at 10:30. पैराग्राफ में से पूछ करके एक जगह करना है. You abandon it. I asked you. करना है. अच्छे से सारा एविडेंस देख लेंगे, समझ गए ना? अच्छे से सारा एविडेंस देख लेंगे, ठीक है? अवेलेबिलिटी ऑफ फंड, कोई जरूरी नहीं है सिर्फ प्लेंटिफ ही बोले. देयर कैन बी अदर एविडेंसेस आल्सो.
Lord, I'll also scrutinize whether 40,000 has been paid or not.
आप देखिए, रिकॉर्ड में देखिए आप. आई डू नॉट नो. ये तो आप रिकॉर्ड छूइएगा तो सब फट जाएगा.
है मैं.
But the requirement is that it should be throughout, right?
Continuous.
Continuous. चलो.
Next case from Delhi list, item 15, second appeal 26 of 2003.
LCR.
The deed, my lord, is relevant in this case, and a copy of which your lordship had asked us to get it typed. The typed copy.
अदर साइड को भी देंगे. अदर साइड को भी देंगे because they need to
My lord,
see it. हाँ, इसमें जो जो अपीयर नहीं हुए ना, उनके पेरेंट्स नहीं रिकॉर्ड करेंगे. मिस्टर राहुल गुप्ता का नहीं रहेगा और भी जो लोग होगा. इधर से मिस्टर इंद्रजीत सिन्हा एंड वो आयुष आदित्य थे, दो ही लोग हैं. और इधर से जो बाकी लोग का नाम डालेंगे, उनका नाम नहीं डालेंगे.
my lord, these substantial questions of law, I read for your lordship's consideration. So whether in view of the recital in Exhibit B, that is the deed, my lord, of adoption, dated 13th of January 94, my lord, 1994. Now, whether in view of the recital in Exhibit B, the courts below erred in law in holding that Musammat Paku Hasda was not governed by Santhal custom and had ceased to be a scheduled tribe. It is she who, my lord, adopts a non-Santhal. Santhal woman, widow, is by this deed, Exhibit B, my lord, has adopted a non-Santhal son of a constable defendant number 1. Santhal widow
has adopted
a non-Santhal by Exhibit B, the adoption registered adoption deed. Which
has
is
adopted a Hindu. Has adopted a Hindu.
adopted
Child was Hindu?
Adopted defendant number 3, my lord.
He was Hindu.
Hindu. No, my lord.
Yes, please.
And the second question, my lord, is whether the provisions of Hindu Adoption and Maintenance Act was applicable in case of adoption by a scheduled tribe of a non-scheduled. Now the point, my lord, for your lordship's consideration is the submission of my lord. the finding of both the courts below that Pakku Hasda, the adoptive mother, Pakku Hasda, had become Hinduized and had adopted Hindu religion by both the courts. Now this finding is wholly contrary to the recitals of the deed, in which all the Santhal Riti Rivaj was performed while being adopted, during adoption. Under the Santhal customary law, as per the recital of the deed. So for these findings are, my lord, contrary to the recital in the deed, my lord, which I will show from the deed, my lord, the relevant portions. इन लोगों का एक देवता होता है बोंगा, बोंगा देवता की उसमें पूजा की जाती है.
संथाल रीति रिवाज का क्या एविडेंस आया है?
कोई एविडेंस नहीं है.
नहीं है तो फिर क्या?
सिवाय की रिवोल्यूशनरी एक चेंज आया है.
Just a moment.
Lord,
Custom is required to be pleaded and proved.
my God,
Right? Custom का क्या प्रूव आया?
कोई प्रूफ नहीं है.
प्रूफ नहीं आया है तो हम आपका ये सबमिशन कैसे रिकॉर्ड करें? संथाल, अगर मान लीजिए जो भी इफ यू से कि संथाल का सारा कस्टम को मतलब फॉलो हुआ है, कहाँ है?
वो डीड में हो.
डीड में तो स्टेटमेंट है,
डीड में रिसाइकल है
रिसाइटल
और हिंदुआइज्ड हो गया, इसके लिए कोई एविडेंस नहीं आया.
ठीक है.
दिस इज व्हाट आई
जजमेंट पढ़िए दोनों कोर्ट. पढ़िए पहले ट्रायल कोर्ट का जजमेंट पढ़िए.
ट्रायल
पहले केस ऑफ रेस्पेक्टिव पार्टीज पढ़ते हैं.
मिलो.
दिस सूट एकदम पैरावन से पढ़िए.
I read, Milo.
यस.
This suit has been presented to get the adoption deed dated 30/09/94, appeared to have been executed by one Pakku Hasda, defendant number 4, cancelled on legal grounds as well as prevailing social custom grounds with the cost. Before I enter into the facts of the present case, it would be convenient to know the relationship of these plaintiffs with the defendant number 4. We are plaintiffs, my lord. The agnates. We are the agnates, my lord. And therefore, locus standi to challenge this verdict because that is debarring our inheritance. Pakku Hasda is the daughter, my lord, of Savna Tuddu, which will come in the plaint also. Savna Tuddu की वो बेटी, सवना टुड्डू का बेटा जटला हंसदा की पत्नी है, मिलॉर्ड, पक्कू हंसदा, और सवना के भाई के औलाद हैं.
सर आप पढ़िए इसको प्लीज बिफोर आई एंटर इनटू. एकदम आराम से पढ़िए.
Before I enter into the fact, it is convenient to know the relationship of these plaintiffs with the defendant number 4 as disclosed in the genealogical table. One Dhani Tuddu had two sons, namely Larha Tuddu and Savana Tuddu. Larha Tuddu has also two sons, namely Karo Tuddu and Dhena Tuddu, my lord, are the plaintiffs, who are the present plaintiffs and number 1 and 2. The other brother, Savana Tuddu, had one son, namely Jatla Tuddu, who is no more in the world. They said Jatla Tuddu had a wife, namely Pakku Hasda, the present defendant number 4, who has no male issue, but a daughter, namely Alodi Tuddu, already married to her place, not a party in the suit. The case of these plaintiffs in short is that the said daughter of the present defendant number 4, namely Alodi Tuddu, bears an ill-reputed character, and she has married 4 times with different persons of the locality. But all the marriages went flop one by one due to her questionable character, and lastly, she developed her illicit relation with defendant number 1, who is a police constable then posted at Devghar. इसी के बेटा डिफेंडर नंबर 1 कांस्टेबल के बेटा को हुजूर अडॉप्ट किया गया. The defendant number 4 and her daughter Alodi Tudu were completely under the clutch and detection of defendant number 1, and thus they all got a so-called deed of adoption created on 30/9/94 at Dumka Registry Office, falsely and dishonestly incorporating their therein that the defendant number 4 adopted the son of defendant number 1 as her son on 13/08/94. It would be relevant to note that the defendant number 2 is the wife of defendant number 1, and defendant number 3 is the so-called adopted son of defendant number 4, now minor in the suit. These plaintiffs further explain that in fact there was no adoption at all by performing any ritual ceremony, or there was any actual giving and taking formality in connection with the so-called adoption. It has been stressed that there is no prevalent custom of adoption in Santhal community by any widow, and that too of custom of adoption by a Santhal to a Diku non-Santhal. It has been introduced further that even after alleged adoption, the defendant number 3, minor boy, has been residing with his parents at Devghar, that is defendant number 1 and 2, at Devghar, and there is practically no transfer of defendant number 3 from the family of his birth to the family of his alleged adoption. It has been alleged that the defendant number 1, in collusion with some interested persons of the locality, forged and fabricated the alleged deed of adoption in order to grab the ancestral land of defendant number 4 as well as that of these plaintiffs. It has been claimed that on the other hand, it is these plaintiffs who are maintaining the defendant number 4, and they are cultivating the entire ancestral lands of defendant number 4 with the land, with other lands. The plaintiffs are the only legal heirs of Savna Tutu. According to Santhal customary law of inheritance, as such, these plaintiffs got right to challenge the alleged deed of adoption. Accordingly, these plaintiffs have got cause of action on 30/9/94 when the said deed of adoption was brought into existence, and also on 25/10/94 when they could know for the first time about the said dishonest deed. Since the present suit in view of these, the plaintiff is one of the declaratory, hence the fixed court fee was payable. But these plaintiffs are members of scheduled tribe, hence they are exempted from paying court fee. The defendants, namely defendant number 1, 2 and 4, have filed common written statement dated 1/8/95. These defendants specifically deny the existence of any customary law, if applicable to the society of Santhals, especially to that of succession, inheritance, marriage and adoption. It has been added that by lapse of time, there has been revolutionary changes in the living style and culture among Santhals in the locality. In fact, the members of the Santhals have adopted the lifestyle of Hindus in every sphere of life, and thereby they have completely followed the culture of Hinduism. A Santhal widow having no son under custom is entitled to take valid adoption, much less having a right to select even a son of Hindu to her choice. It has been added further that in the locality the temple of famous Baba Baskunath is situated, and the Santhals of the locality used to offer worship to Baba Baskunath with all religious sincerity. The family of these plaintiffs as well as that of defendant number 4 are quite separated since long ago, and thus practically they have formed separate family, having no concern with each other in any manner. The defendant number 4, her daughter Alodi Tutu, and the adopted son, the defendant number 3, all are living jointly in the house of the defendant number 4. And the defendant number 4, my lord, is Pakku Hasda, the adoptive mother. And the property of the husband, defendant number 4, which has been competently survived by her, are in their possession and occupation. The allegation of ill character of daughter of defendant number 4, who is even not a party in the suit, is also bogus, imaginary, and out of product of legal brain, and it has been leveled with a purpose to make out the present case. It has been introduced that the defendant number 4 on 13/08/2025 performed all legal customary ceremonies of puja etc. in presence of the villages, including these plaintiffs and others, adopted the name of defendant number 3 was changed, and now he is known as addressed as Kumar Mahesh, son of late Jharkhand. Thus, the status of the defendant number 3 now stands changed and practically is transferred to the family of the respondent 4 and presently residing with the respondent defendant number 4, observing all rituals of a son. The deed of adoption was accordingly executed by the defendant number 4 validly on 30/9/94, wherein the defendant number 1 and 2, being the parents of adopted son, also joined their hands, further witnessed by several persons of the locality, including village Pradhan Govind Tudu, who is none else but own nephew of the present plaintiff. It has been stressed that on the eve of adoption of defendant number 3, a local ceremony known as Nimda Mari. Now this is important, my lord. Santhal customary ceremony is there. Nimda Mari meaning as renaming of adopted boy performed in the locality. A Santhal widow has valid right to adopt according to prevailing custom in the Santhal society, and there is no bar to adopt Dikku or a Hindu boy in adoption by a Santhal, as the two societies are so intermingled in each other in the locality, and they pass their time jointly and share the feelings together. These defendants emphatically denied the adoption deed to be either forged or fabricated. So far it relates to the claim of the plaintiff that they maintain the defendant number 4 is nothing but a bundle of falsehood, and these plaintiffs had never occasion to cultivate the lands of defendant number 4, as the share of the husband of defendant number 4 was also separate in the lifetime of a deceased husband, having no concern whatsoever with these plaintiffs or with their ancestors. Thus, these plaintiffs can never be said to be legal heir of Sivana Tutu or his son Jatla Tutu when the defendant number 4 is still alive. These plaintiffs have no locus standi to challenge the adoption, and the adoption deed is thus valid, genuine, correct, and legal. These defendants further challenge the valuation raised in the suit on the ground the court fee should have been paid on the valuation of the property of the husband of the respondent before. Besides these specific facts, these defendants raised some general pleadings like the suit is not maintainable, plaintiffs have got no cause of action since the nomenclature of the defendant number 3 has been changed, hence should have been properly addressed and this suit is won against wrong person. On the basis of these facts, these defendants pray to dismiss the suit. It would not be out of place to mention here that the defendant number 3, who is minor boy, was ordered to be represented by guardian at Lighton, who is in his written statement dated 4/8/98 virtually adopted the facts pleaded in the written statement filed by the defendants 1, 2, and 4. A genealogical table has also been shown in para 5 of the written statement of the defendants, since both the parties under litigation represent their common ancestor Dhani Tudu. Hence, it would be useless to see the class of brothers of Dhani Tudu in this case. However, the relationship of these parties, meaning thereby that of the present plaintiffs and the defendant number 4, appears to be admitted. This is the finding, my lord, as regard the relationship with the plaintiffs. This fact is almost admitted that the defendant number 4, being a Santhal lady, has adopted a Hindu boy. Defendant number 3, the plaintiffs challenged the adoption mainly on the ground of the prevailing custom in the Santhal
That's
society.
right, finding 9. Issue number 4 and 5.
Since the facts of the present suit revolve.
What is the evidence that PW4, yes, defendant number 4 was practicing Hinduism?
No finding except sweeping statement has come, my lord, in the written statement as well as evidence कि हम लोग वो बासुकीनाथ और टेम्पल उम्पल वगैरह में जाते हैं और DW6 my lord is Virasapati Rai, defendant number 1, who was examined in this case and he admitted कि ऐसा कोई भी हम दिक्कू में adoption हुआ हो संथाल नॉन संथाल में, ऐसा एक भी कोई संथाल या कोई गवाह हम लोग प्रोड्यूस नहीं कर पाए, एक भी कोई इंसिडेंट वैसा
नहीं होगा, लेकिन इसका मतलब ये नहीं है कि बार है।
नहीं बार
Has he stated that there is a bar?
बार इसलिए है,
इसलिए नहीं। Has he stated that there is a bar?
ये
Has he stated that what are the rules, regulations so far as adoption in Santa, or there is no concept of adoption in Santa?
no concept of adoption is there,
What are the rules and regulations?
but within the community.
कहाँ लिखा है? Where is that evidence that it can be adopted only within the community?
For that, my lord, I will cite section 20 of the SP Tenancy Act. My lord, the entire Santhal laws.
Section 20 का बात नहीं चलेगा sir. Section 20 से नहीं चलेगा.
नहीं kindly see, my lord.
आपको when you are talking about custom of adoption, you have to prove the custom of adoption.
नहीं तो हमारा ये कहना है कि संथाल कम्युनिटी का सैक्रोसैंक्ट अपना पर्सनल लॉज है और पर्सनल लॉज के अनुसार उन
ये क्या आपका
लोगों
SPT is personal laws?
हाँ?
No, it is not a codification of personal law of Santhals. SPT is not a codification of personal laws of Santhal. Personal laws of Santhal is governed by their customary law.
True,
So
ma'am.
you tell us what is the finding regarding the ways and means and the rituals and exception with regard to adoption of in the Santhal community. Where
No.
is the finding?
Lord, one thing your lordship will kindly appreciate.
So, पहला तो आप ये समझ लीजिए, if the moment you say custom, it has to be pleaded and proved. The onus is absolutely on you, right? This is the law.
Lord, it is they who are, Lord, pleading that they are converted to Hinduism and therefore
That
they
is
can.
another thing. Once they are converted into Hinduism, that is a separate issue. The
Lord,
moment you say that there is a bar amongst custom, that no outsider can be taken into adoption, where is that evidence?
Lord, for that, my Lord, we will have to go into section 20 of the SPT
Section
Act
20
also.
से नहीं covered होगा sir. Section 20 is for a separate purpose altogether.
My Lord, the संथाल कम्युनिटी के अंदर अगर adoption नॉन संथाल का होने लगेगा तो entire संथाल laws will stand defunct, my Lord, because it is for protection of their families
Sir.
and the properties. The entire Santhal law is based on that, my Lord. Even the survey settlement operations reports, my Lord, which are there in the SP manual also, which I will read, my Lord. My Lord,
Is there-
and therefore, my Lord, Therefore, one custom is there, my lord, under the Santhal.
सर आपका
कि
लेक्चर
अगर
नहीं
बेटा नहीं
चाहिए
है, pardon लो,
सर हमें जनरल लेक्चर नहीं चाहिए on customs.
जनरल नहीं दे रहे हो।
आप हमको एविडेंस दिखाइए आपका कस्टम हम सीधा एविडेंस देखेंगे और कुछ नहीं देंगे
हुजूर,
ना अपना पर्सनल नॉलेज इंप्यूट करेंगे ना आप
हुजूर, this is an admitted
नहीं
fact.
एडमिटेड फैक्ट कुछ नहीं होता है
The-
सर
the
देयर इज नो
custom-
कॉन्सेप्ट
कस्टम एडमिटेड है दोनों साइड से
कहाँ
कि
से एडमिशन
कि-
दिखाइए
कि
ना
नहीं, अगर बेटी है तो घर जमाई शादी करके
सर
घर जमाई आ
घर जमाई
जाए।
का कोई स्टोरी नहीं है ना इसमें सर प्लीज हमको स्टोरी मत सुनाइए ये घर जमाई का कोई स्टोरी नहीं है
हुजूर,
So we are
इसमें-
not bothered about
इसमें
घर
आया
जमाई।
है कि she has one daughter,
सो
she has one daughter, तो she could have married my lord in घर जमाई फॉर्म, जो एविडेंस में नहीं आया।
नहीं किया ना शादी
तो संथाल कस्टम में घर जमाई इज परमिसिबल
नहीं
वेयर
उसने
सन
शादी
इज
नहीं
नॉट देयर।
See, the daughter did not get married. The daughter did not marry the police constable. Did she marry? No.
नो, she married 4 times.
4 बार क्या 40 बार शादी करे लॉ में बार है क्या
ठीक है, लेकिन
ये सब क्या
उसकी
बोल रहे
शादी
हैं आप?
घर जमाई में
जैसे
नहीं
जैसा
हुई
लैंग्वेज
है।
यहाँ जजमेंट्स में रहता है वैसा वैसा लैंग्वेज आप लोग भी
हुजूर,
बोलते हैं।
घर जमाई में शादी करने का कस्टम है वो लोग के यहाँ, इसलिए अडॉप्शन बाहर से किसी को कहेगा लाएंगे। हुजूर, हियर इट इज अ केस, योर लॉर्डशिप विल काइंडली अप्रिशिएट दैट इट इज एन एडमिटेड फैक्ट दैट शी हैज वन डॉटर अलोदी हसदा मिलॉट, and Alodi Hasda was not married in घर जमाई form, and the Santhal custom permits that because घर जमाई is an adopted son, assumes the entire character, nature and character of an adopted son, my lord. This is what there are so many decisions of this honorable court कि घर जमाई में जिसकी शादी हो गई और इसीलिए है कि चूंकि अब बेटी है तो therefore she can marry बेटी इन घर जमाई एंड ब्रिंग, और वो फिर आके घर जमाई के रूप में रहने लगता है एंड इनहेरिट्स द एंटायर प्रॉपर्टी, ताकि दूसरे वंशज में नहीं चला जाए। सो ऑन दिस लॉर्ड द संथाल लॉ इज वेरी सैक्रोसैंक्ट। अगर बाहर से आकर एडॉप्शन इस तरह से होने लगेगा तो संथाल एक्सटिंक्ट हो जाएगा। जैसा पहाड़िया सब ग्रेजुअली एक्सटिंक्ट हो रहा है, संथाल भी धीरे धीरे एक्सटिंक्ट हो रहा है। एंड इट इज ओनली टू प्रोटेक्ट देयर फैमिलीज एंड प्रॉपर्टीज, लॉर्ड द एंटायर कस्टमरी लॉ इज बेस्ड ऑन।
जल्दी मंगाइए तो।
एक भी इंस्टांस लोग नहीं साइट कर सका कि नॉन दीकू को एक संथाल ने अडॉप्ट किया हो। दिस हैज कम इन PW6 मिलॉर्ड, डिफेंडेंट नंबर 1 अपने बोल रहे हैं। तो व्हेन दे से कि नो इट इज परमिसिबल, अब चूंकि वो हिंदू हो गए हैं इसलिए, तो हिंदू का भी तो कोई प्रमाण उस तरह से आया नहीं है। एंड इवन इफ हिंदू भी हो जाते हैं तो यू कांट मिलॉर्ड override the Santhal laws. अगर जमाई के कस्टम को लेकर लॉ ऑफ इनहेरिटेंस है, वो सर्वे एंड सेटलमेंट रिपोर्ट रिपोर्टेड इन आवर मैनुअल ऑल्सो। So wholly collusive deed.
आप अपना बहस करिए, हम सुन रहे हैं। आर्ग्यू योर पॉइंट ऑफ व्यू वन बाय वन। बैकग्राउंड उनको मिल गया, आप अपना पॉइंट ऑफ व्यू बहस करिए।
Lord, page 89 of the SP manual.
क्या है पेज 89?
abstracts from revision and survey settlement operations, my lord, are given at page 89, my lord. Santhal tribal law of inheritance.
कहाँ है संथाल का? पेज 89 में तो कुछ नहीं।
सीरियल
कौन सा?
37 करके
ये है।
पेज बदल सकते हैं, निकाल दो। And then in the recital of the deed, my lord, I will also read out a few lines जिसमें ये लोग संथाल रीति के अनुसार adoption कर रहे हैं. And now in the written statement when the suit is filed, they say कि Hinduized हो गए, which is an afterthought.
सर आप अपना बहस कंटिन्यू करिए प्लीज. डू यू गेट इट सर? प्लीज यू कैन वेस्ट माय टाइम लाइक दिस. आप अपना बहस
इसमें
कंटिन्यू करिए.
पेज मिल नहीं रहा, लेकिन जो है वो उनके सामने.
जो चीज आपके पास है वो हम कैसे पढ़ें? जो चीज आपके पास है और मेरे पास नहीं है हम कैसे पढ़ें? संजय तो हम हैं नहीं.
इसको फोटो करके दे देंगे.
वो किताब लाइए ना. ये है तो ये देखिए ये किताब है.
ओल्ड एडिशन का एक था.
ये किताब है.
हाँ, ये इसमें
दीजिए उनको निकालने.
एक लो. सीरियल 37 का
सर अभी क्या पढ़ रहे हैं?
हम पढ़ रहे हैं संथाल ट्राइबल लॉ ऑफ इनहेरिटेंस. These are abstracts from revision survey settlement operation, which are binding. According to Santhal law, only males can inherit land. Sons jointly succeed their father. If brothers are co-sharers, in a whole
सर
day.
इनहेरिटेंस की बात ही नहीं कर रहे हैं, इनहेरिटेंस की बात नहीं है, whether somebody can adopt or not adopt.
तो वही हम प्लेस कर रहे हैं. Of
Sir,
course, subject
there
to-
can be a situation that in spite of adoption he will not inherit.
Milord, there is already a custom when daughter is there, because male can only inherit. Son नहीं है और बेटी है, तो उसका आप घर जमाई शादी करके आप घर जमाई को ले आइए, वो अडॉप्टेड सन हो जाएगा. इस पर डिसीजन सब है हमारे.
मतलब बिना शादी किए कोई लड़की कुछ अडॉप्ट नहीं कर सकती है, उसको शादी करना जरूरी है, मैंडेटरी.
मैंडेटरी है वो अंडर द संथाल लॉ.
ऐसा इंटरप्रिटेशन तो हम बिल्कुल ही नहीं कर सकते.
अदरवाइज वो एग्नेट्स में चला
शादी
जाएगा.
मैंडेटरी है तो ये सब कहानी तो बहुत मुश्किल.
हुजूर एग्नेट्स में चला जाएगा नहीं.
सर इनहेरिटेंस की कहानी नहीं है. द स्टोरी इज वेदर वन कैन अडॉप्ट और वन कैन नॉट अडॉप्ट.
ए दीकू नॉन संथाल
यस.
माय लॉर्ड्स.
सो अब एडॉप्शन की बात करिए ना, आप ये इनहेरिटेंस की क्या बात कर रहे हैं?
Adoption means that will result into inheritance.
We do not know what will it result into.
Adoption का इसमें कहीं कुछ इस तरह से संथाल लॉ में नहीं दिया है, और वो भी आप नॉन संथाल को ले आइए.
तो संथाल में एडॉप्शन इज नॉट परमिसिबल.
विद इन संथाल परमिसिबल.
कहाँ से बोल रहे हैं? वेयर इज द एविडेंस? जब आप कस्टम की बात करते हैं तो एविडेंस दिखाइए, लॉ की बात करते हैं तो स्टैट्यूट दिखाइए.
एविडेंस नहीं है.
नहीं है ना, बस फिर क्या बचा? क्वेश्चन ऑफ लॉ बना है एग्जिबिट बी पर, एग्जिबिट बी पढ़ी.
मामा रेलेवेंट पोर्शंस पढ़ दें कुछ.
आपकी मर्जी है सर, एग्जिबिट बी पर है तो आपको जो जो पढ़ना है सब पढ़िए, हम आपको नहीं रोक सकते.
Lord, the third page. ऊपर से पढ़ दे रहे हैं. इसके लिए भी पुत्र का होना जरूरी है. ये सब सोचकर गोद गृहिणी ने एक योग्य बालक को अपना गोद लेकर दत्तक पुत्र बनाने की सोची और एक योग्य बालक की तलाश करने लगे. आखिर अपने ही गांव के श्री बृहस्पति राम राय के पुत्र बबुआ महेंद्र को देखा, जो बेहद पसंद आया. करने के कारण ही गोद गृहिणी ने उक्त आलक बबुआ महेंद्र को जन्मदाता माता पिता ने उक्त बालक को अपना गोद पुत्र बनाने के लिए मांगी. गोददाता सब दंपत्ति ने अपने में सलाह मशवरा करके उक्त बालक को गोद गृहिणी की गोद में देने के लिए सहर्ष तैयार हो गए. तब गोद गृहिणी ने एक शुभ दिन देखकर अपने भैंसुर करियो टुड्डू पिता सुरंसो से राय लेकर अपने हित कुटुंबों को निमंत्रण देकर 1394 रोज बृहस्पतिवार शाम करीब 4 बजे अपने बोंग देवता, नाउ दिस इज नॉट, इस संथाल देवता बोंग देवता का संथाली रीति रिवाज मुताबिक पुत्र हवन करके, वो भी संथाल रीति रिवाज मुताबिक नींदा मारी का रस्म पूरी करके गोददाता दंपत्ति की गोद से उक्त बालक बबुआ महेंद्र को सभी उप सज्जनों के समक्ष अपना गोद ले लिया और गोद लेकर उक्त बालक को पुराना नाम महेंद्र राम बदलकर नवीन कुमार महेंद्र रखा. सभी उपस्थित सज्जनों. नाउ देयर आफ्टर मिलॉर्ड, देन मिलॉर्ड पेज 5 में, उसमें भी फिर ये जिक्र आता है बोंगो देवता टुवर्ड्स मिडिल. बृहस्पति राम एवं श्रीमती सरस्वती देवी ये इकरार करते हैं और लिख देते हैं कि तिथि 1394 रोज बृहस्पतिवार संध्या करीब 4 बजे गोद गृहिणी के घर जाकर उसका बोंगा देवता के समक्ष करके अपने उक्त पुत्र या ओरिजिनल से दिखा देंगे। ओरिजिनल का पेज
आप इसी का पेज नंबर बताइए।
मिनट पेज 5 है मैम,
ठीक।
पेज 5 टुवर्ड्स मिडिल आई वाज रीडिंग। हम लोग गोददाता दंपति श्री बृहस्पति राम एवं श्रीमती सरस्वती देवी यह इकरार करते हैं और लिख देते हैं कि तिथि 13/94 रोज बृहस्पतिवार संध्या करीब 4 बजे दूध गृहिणी के घर जाकर उसका बोंगा देवता के समक्ष करके अपने उक्त पुत्र महेंद्र राम नवीन कुमार महेंद्र को अपना गोद में उठाकर गोद गृहिणी के गोद में दे दिया है। तभी से उक्त बालक गोद गृहिणी के साथ रहता है और हम दावा से उक्त बालक महेंद्र का अब कोई संबंध नहीं रहा। अब यह बालक हमारे कुल व गोत्र से निकलकर गोद गृहिणी के कुल में चला है, ट्रांसफर टू द फैमिली। So submission, my lord, for your lordship's consideration, the finding that Hinduized is not, my lord, covered by recitals, my lord, of the deed. It is afterthought, and then no specific incident has been cited in the whole of evidence कि कभी भी नॉन संथाल ने कोई दिक्कू को अडॉप्ट किया। This is my submission for your lordship's consideration, my lord.
और ये जो इसका सेकंड पेज जो आप नहीं पढ़े उसके बारे में आपको क्या बोलना है?
सेकंड पेज विदित हो कि लेखकारीगण गोद गृहस्थी की उम्र 55 वर्ष की हो चुकी है तथा पति का स्वर्गवास हुए 7 वर्ष हो चुका है, इनसे उत्पन्न कोई संतान नहीं है। हिंदू धर्म एवं संथाल रीति अंतिम संस्कार मुखाग्नि कर्म श्राद्ध कर्म किया आदि के लिए एक पुत्र का होना, कोई संतान नहीं है। दिस इज एन एरर ऑफ रिकॉर्ड इन एविडेंस शी हैज सेड, और इसी को इंटरप्रेट किया है वो ट्रायल कोर्ट ने ये कहते हुए कि इसका माने हुआ कि कोई बेटा नहीं। ट्रायल कोर्ट, दिस इज हाउ,
मतलब बेटी संतान नहीं होती, बेटी इज नॉट अ संतान।
नहीं संतान नहीं, मैंने दिस इज हाउ लॉर्ड दिस वाज इंटरप्रेटेड बाय
डॉटर इज
द
नॉट अ
ट्रायल
संतान।
कोर्ट।
ये कौन तरह का बहस है आपका? डॉटर इज नॉट अ संतान।
नहीं नहीं संतान क्यों नहीं,
संतान
संतान तो है ही।
तो या बोले संतान नहीं।
नहीं नहीं मेल नहीं, इसी को इंटरप्रेट करके कहा कि
जस्ट अ मोमेंट, हिंदू धर्म एवं संताल रीति रिवाज मुताबिक अंतिम संस्कार मुखाग्नि कर्म श्राद्ध करने के लिए एक पुत्र का होना जरूरी है।
हाँ
ठीक है, दिस इज द हिंदू लॉ, वी नो एक पुत्र का होना जरूरी है फॉर दिस पर्पस, राइट? She is adopting by saying that for the purposes of for performance of a shradhkarm mukhagni, this is required, right? संथाल में कैसे होता है लास्ट राइट्स, कैसे होता है
suppressing the fact of daughter, my lord.
कोई बात नहीं। संथाल में
She has a daughter.
संथाल में लास्ट राइट्स कैसे होता है? संथाल में लास्ट राइट्स का क्या प्रोविजन? what is the
उसमें तो कुछ लोग दफनाते हैं, कुछ लोग मुखाग्नि भी देते हैं।
so the whole purpose
बहुत से
was,
क्रिश्चियन हो गए, अब मुस्लिम भी उसमें एंटर कर रहे हैं।
तो जब
लोग
दूसरे,
हिंदू
you see the moment you change your religion, अभी सुप्रीम कोर्ट का 3 जजमेंट आया, झारखंड से एक भी नहीं है, झारखंड से एक भी नहीं है। there are 3 judgments of Supreme Court. The moment you change your religion, right, you are not entitled to the benefit of guidance because you give up all the customs, everything. आप कहाँ उसको follow कर रहे हैं? The moment a person is converted into a Christian or converted into Muslim, will he perform all these ceremonies? नहीं करेंगे ना,
तो यहाँ कन्वर्शन नहीं हुआ.
इन जनरल हम बोल रहे हैं,
हाँ, मिलोट,
नहीं होगा ना.
मिलोट.
There is a concept of Hinduized tribals. There is a concept. That is a legal concept recognized by various judgments that there are some tribals who are migrating and getting themselves Hinduized, and they are to be treated Hindus in the society, and also for the purposes of law. Correct? Okay. Lekin for the purposes of other religion, there is no such concept. There has to be a conversion, and then only he can profess other religion. Like in order to become Mohammedan, one has to perform certain ceremony, and then only he will be
Convert.
entitled and get converted. Similarly, for Christianity, there is a proper ceremony, and then only he gets converted. But for tribals and Hindus and Hinduized tribes, there is no ceremony is required,
मिलोट, मिलोट.
isn't it?
माय.
चलिए आगे क्या बोलना है.
Look, these are my humble submissions for your lordship. Not permissible because daughter is there suppressed in the deed, which has been interpreted by the trial court कि नहीं वो मीन कर रही थी कि बेटा नहीं, संतान नहीं है करके आया है. So there it's a suppression. There the very fact that the mother who is adopting has come out with, has suppressed the fact that she has a daughter called Aludi Hasda. So therefore, in that way also, this deed, I mean, is void on the face of it.
उसपे कोई
And
क्वेश्चन
then,
ऑफ लॉ
and then,
नहीं,
pardon?
उसपे कोई क्वेश्चन ऑफ लॉ नहीं बनता.
उसमें क्वेश्चन ऑफ लॉ ऑफ कोर्स सबमिशन मेरा दे दिए मालूम कि there is a custom when daughter is there, the संथाल custom permits a घर जमाई to come and assume the character of adoptive son. There is already a custom there. Now this has been suppressed.
The learned counsel for the appellant, while referring to the substantial question of law, has referred to Exhibit B, which is the registered deed of adoption, and has submitted that it has been suppressed by respondent number 4, by the defendant number 4, that she had a daughter. He submits that the term santan, Hindi में italics में, has been interpreted to be son. The learned counsel has submitted that as per santan law of inheritance, the daughter does not inherit the property. Rather, the inheritance is by performing Gharjamai form of marriage. And once Gharjamai form of marriage is performed, as per law, the Gharjamai acquires the status of a son and inherits the property. The learned counsel has also referred to the recitals in the deed to submit that the various ceremonies by referring to Vang Devta and referable to Santal custom, and further the ceremony of Neem Damra and handing over and taking over of the child has been mentioned in the deed of adoption. Which itself goes to show that the defendant number 4 was a Santal and not Hindu, and according to the finding of the learned court that she was a Hinduized Santal and was governed by Hindu religion and was governed by Hindu Adoption and Maintenance Act 1956 is not correct. The learned counsel submits that the defendant number 4 being a tribal, the Hindu Adoption and Maintenance Act does not apply. He has also submitted that there is no concept of a Santal lady taking anybody in adoption. He has also submitted that otherwise also a Santal lady cannot adopt a Hindu as per customary.
or non-Santal.
Hindu or non-Santal as per customary law of Santal. चलिए, ये हो गया आपका दोनों सब्सटेंशियल क्वेश्चन ऑफ लॉ कवर्ड. ठीक, आप बताइए सर, आपको क्या बोलना है?
इनका तो कोई एविडेंस नहीं है कि ऐसा
May I
custom-
beg leave? With your lordship's leave.
नहीं, हम तो आपको लीव नहीं दे सकते इन द मिड्स ऑफ द प्रोसीडिंग्स, बट इफ यू वांट टू गो यू कैन गो. आप ही बताइए, आपको रिस्पॉन्ड नहीं करना है, दैट्स योर ऑप्शन. आई डोंट वांट टू से एनीथिंग.
हम आ रहे हैं.
अच्छा,
इसमें इनके द्वारा कोई एविडेंस नहीं है, ऐसा कोई कस्टम नहीं है, ऐसा कहीं पर आया नहीं है कि गैर संथाल को नहीं लिया जा सकता है. उसके बाद विडो हैज द राइट टू अडॉप्ट, इसका जवाब भी नहीं किसी हाई कोर्ट में डिसीजन भी दे दिया है. 2009 का वॉल्यूम 1 जेसिया पेज.
there is no evidence that आपका
There is
पहले
no
से
evidence with respect to the custom that a Santhal cannot adopt a non-Santhal. There is no evidence.
yes.
दूसरा जो इन्होंने कहा कि विडो हैज नो राइट टू अडॉप्ट, वो घर जमाई क्रिएट कर सकती हैं, एडॉप्शन नहीं हो सकता है. इस बात का जवाब हुई इसी कोर्ट में हो गया. ये केस है नारायण सोरेन वर्सेस रंजन मुर्मू. ये केस रिपोर्टेड इन 2009 जेसिया वॉल्यूम 1 पेज 262. बहुत सारे चीज को इसमें बिल करते हुए कस्टम को एग्जॉस्टिव जजमेंट जिसमें आया ये जो बिल किया गया कि विडो हैज ए राइट टू अडॉप्ट एंड विडो ए परमानेंट विडो इन ए ज्वाइंट फैमिली, उसका स्टेटस. इस किताब को जरा सा काइंडली इस साइटेशन को देख लिया जाएगा. इट्स
सर साइटेशन आप दीजिए हमको.
जी.
ये
just incidentally, my good friend was a counsel in that case, and it was his case there also, that the Santhal widow cannot adopt. And that has been answered by the Supreme Court. They exhausted that. Paragraph 18 में है the customary law of adoption prevailing in the Santhals has been recognized in the Santhal Permanent Tenancy Separate Provision 1949 Section 20 of the State Act to put a restriction in the transfer of collective holding by way of the transfer of holding except with the written permission of the Constitution. Section 20 of the Act however provides some relaxation in the transfer of holding. Where accepting mortgage, bank, and to the society registration of certain transfers. And it has been dealt thereafter taken with the other decisions of the Honorable Supreme Court. One case of AIR 1935 Lahore, the case of Parker Bibi versus Hinduization. These things have been there. Lastly, Lord, take the help that the Santhal in that case had taken in adoption by the widow. Santhal widow had taken.
कहाँ से बोल रहे हैं? From where are you? From where are you reading?
जो पढ़े हो
इसमें तो विडो का कोई बात नहीं है.
अब जैसा यहाँ पर आया है पेज 265 पर देखा जाए दी परमानेंट विडो इन ए ज्वाइंट फैमिली सब पैराग्राफ शुरू होता है इफ दिस इज द पोजीशन व्हेन विडो remarries what are the rights of if she does not take another husband but remains a widow in such a case she is virtually a substitute of her husband. She steps into the have you got पेज 265 में विडो बाएं तरफ से
कोर्ट का फाइंडिंग दिखाइए ना, ये तो सिर्फ रिसाइटल्स हैं.
जी पेज 269 पर पैराग्राफ 16 देखा जाए पैराग्राफ 16 onwards from the aforesaid discussion बाएं तरफ से in the aforesaid discussion it is evidently clear that custom prevailing in Santhal community has undergone a great change. The rules against filial succession among the Santhals, whether Christian or non-Christian, are changing owing to the force of public opinion. The change which is occurring is in the direction of uplifting the condition of women and giving them right in the family and also in the property. From the books of great scholars who are the authors of many books, including the books in survey and settlement quoted here in the above, it is manifestly clear. There are instances where a sonless male or a female have taken in adoption a grandson or any of the ignorant support. In the case of Madhukishwar and others, the state of Bihar and so and so provisions which provides succession property in the male line was challenged as discriminatory and unfair against women, and therefore adheres to the equality clause in the Constitution. In the said case, the Supreme Court has overruled. Now it has been reported. The public policy and the constitutional philosophy is decided under the Article Social is to accord social and economic democracy to women as assured in the preamble of the Constitution. They constitute the core foundation of the economic empowerment and social justice to women and stability of the political democracy. In other words, they frown upon gender discrimination and aim at the elimination of obstacles to enjoy social, economic, political, and cultural rights on equal footing. Law is living organism and utility depends on its ability and ability to serve as a sustaining pillar of society. Tutors of law and a well-being society must constantly keep changing as civilization and culture advances. Custom and mores must undergo change with the march of time. Justice to individual is one of the highest interests of democratic state. Judiciary cannot protect the interest of human being unless it would redefine the protection of the Constitution and the common law. If the law is to adapt itself to the needs of the changing society, it must be flexible and adaptable. Law of manifestation, of principle of justice, equality in legal science, rule of law should establish a uniform pattern of harmonious existence in a society where every individual will exercise his right to his best advantage to achieve excellence, subject to productive discrimination. The best advantage of one person would be the worst and disadvantage to another. Law steps into iron out such results and ensures equality of protection to an individual as well as group liberties. Men's status is creature of substantive as well as the procedural law to which legal incidents would attach justice, equality, and fraternity are in trinity to social and economic equality. Therefore, law is foundation of which the potential of the society steps. The Lordship further observed as per the UN report 1980, women constitute half of the world population, but for nearly 2/3 of world hours, receive 1/10 of the world's income, and own less 1/100th of percent of the world's population. Half of the Indian population who are women. Women have always been discriminated against and have suffered and are suffering discrimination with silent self-sacrifice and self-denial. Are their nobility and fortitude, and yet they are subjected to all inequalities, indigence, inequalities, discrimination, Article 13, 14, 15, and 16 of the Constitution of India, and other related articles with discrimination on the ground of sex, social and economic. Democracy is the cornerstone of the success of the political democracy. The scheduled caste, scheduled tribes, and women from time immemorial suffered discrimination and social inequalities made them accept their ascribed social status. Among women, the tribal women are lowest of low. It is mandatory, therefore, to render them socio-economic justice so as to ensure their dignity of person, so that they be brought into the mainstream of the national life. We are conscious that in Article 25 it defines scheduled tribes were not brought within its fold to protect their custom and identity. We keep at the back of the mind. customary law of adoption prevailing in Santals has been recognized in the Santhal section. I have already written. Registration of certain transfers of property in a property holding of any goods whereof is transferred, the sale gift to be extended in accordance with the provisions of this Act, the record of right transferring or his successor in title may cause the transfer to be registered in the office then or village, notwithstanding anything to the contrary, so and so, or it has been referred to. It will not be included. Lord says, paragraph 20, paragraph number 20, be that it, as it may, the only substantial question of law needs to be answered in this appeal is as to whether the courts below have erred in law in placing the onus of the plaintiff on the plaintiff, prove that there was custom of adoption by female among the Santals. In my considered opinion, where plaintiff asserts that adoption of a child by female is not customary in Santals, and the defendant discharged the onus of adducing evidence to show that the adoption of child by female Santal is customary, then heavy onus lies on the plaintiff for proving that such custom of adoption of a child is not customary in Santals. In the case of so and so, 1935 of Lahore, page 325, the division bench of the Lahore High Court, we may say at once that decision of the case has proceeded on the entirely erroneous grounds, even since their lordship of the council have decided in 1974 the law has been very clear that when a person asserts that he is governed by custom, it is incumbent upon him to prove that he is so governed, and further to prove that custom is, there is no uniform custom.
Where is the finding of the learned trial court that the defendant number 4 was Hinduized?
Yes. That was not the Lord, your lordship will kindly find.
Where is the finding?
Paragraph 16. Paragraph 6, from the aforesaid discussion, it is evidently clear that the custom prevailing in Santhal community has undergone a great change. Paragraph 16.
Paragraph 16.
Paragraph 16.
16.
One
Sir,
six-
trial court का judgment.
Page those 16.
Trial court का judgment.
Trial court का judgment.
Trial court में कहाँ finding? That she was Hinduized.
वो बास्किनाथ वगैरह में पूजा करने जाती थी, ये सब था, इसका आया है, देख रहा है। पेज 9 आया जाए तो ट्रायल कोर्ट का जजमेंट में जस्ट ए पैराग्राफ begins the facts of the plaintiff as referred in paragraph number 8 of the plaint to disclose that there is no prevalent custom of adoption in Santhal community by any widow, and that too there is no custom of adoption of any widow by any Santhal community as discussed above. There is no rule shown in this regard which restrains the system of adoption in Santhal community. On the other hand, section 24 of the Santhal Tenancy deals with the rules of registration of state transfer of right holding, clearly describes in sub-clause 2b proviso, which reads in the following words: provided that a gift to the husband or wife of the donor or to a son adopted under the Hindu
Sir, ये
law.
नहीं पूछ रहे हैं. हम ये जानना चाहते हैं. Is there any finding by the learned trial court that she was sufficiently Hinduized.
वो है just a minute. जैसा पेज नंबर 11 में बीच का पैराग्राफ जो शुरू होता है जरा से इसको देखा जाए. The plaintiff striked the very deed of adoption. पाया गया. Plaintiff striked the very deed of adoption on the ground that the evidences are available by DW6 paragraph number 4 and DW3 paragraph number 4 that on the eve of adoption puja according to Hindu custom was performed in presence of Pandit Sarjuni Shah and puja of Satyanarayan Katha was also observed. Introduction of this fact clearly shows that adoption of defendant number 3 was observed by custom through Santhal process as well as the Hindu custom too. I do not find any wrong because after all, defendant number 1 and 2 who belong to Hindu custom would have pressed the defendant number 4 to observe the Hindu custom also as observed earlier since the two societies are so intermingled to each other. It is possible that both customs would have been observed. Above all, we will do going to who is a member of the same family, of the family of the plaintiff as well as the defendant number 4, have come before the court to support the giving and taking the defendant number 3 in adoption. The rituals of adoption of the defendant number 3 can be seen otherwise.
सर आपसे एक सवाल पूछ रहे हैं, आप पूरा जजमेंट पढ़े. हम
नहीं,
ये
जजमेंट
फाइंडिंग
हम इसको दिखाए ना आपको कि वो
नहीं,
Hinduized-
फाइंडिंग दिखाइए कि
Hinduized
हिंदुआइज्ड है.
एविडेंस कह रहा है ना कि ये दिखला
सर
रहा है
एविडेंस
कि
का नहीं, फाइंडिंग का पूछ रहे हैं. आई एम नॉट टॉकिंग अबाउट डिस्कशन ऑफ एविडेंस. पूरा जजमेंट हम लोग पढ़ चुके हैं.
Finding
ऐसा
तो
कोई
आ गया.
फाइंडिंग दिखाइए दैट शी वाज हिंदुआइज्ड.
फाइंडिंग तो ये आ गया कि ये एडॉप्शन जो है सो वैलिड है. ये तो आ गया फाइंडिंग.
वो तो फाइंडिंग आ गया.
तो जो एडॉप्शन वैलिड है दोनों कोर्ट कंकर कर दिया. फिर हुजूर सेकंड अपील में इनके लिए कहाँ स्कोप है कि इस चीज को भेजते हैं.
ठीक.
बोथ द कोर्ट्स हैव सेड सो.
आपको कुछ बोलना है ऐसे?
और इसके अलावा हुजूर वो जो
और the
हिंदुआइज्ड
learned
का तो आ ही गया है.
counsel on behalf of the
हिंदुआइज्ड का
parties. Essay number 26 of 2003.
अच्छा.
The judgment that has been cited that relates to a widow's right. In that case, Lord, a Santhal widow adopting a Santhal.
अच्छा, एक second. The learned counsel for
Not
the
Santhal
respondents
widows.
has opposed the appellants and has submitted that there is no legal bar of a Santhal lady adopting the adopting Hindu as by way of adoption. The learned counsel has also submitted that the ceremonies of both Santhal as well as Hindu were followed. He has also submitted that there was enough evidence that the defendant number 1 was sufficiently Hinduized. However, he has submitted that irrespective of whether she was Hinduized or governed by Santhal law, the Santhal customary law, the deed of adoption is valid inasmuch as no such customary law has been proved by the plaintiff that a Santhal woman cannot adopt a Hindu boy. The Learned Council has relied upon the judgment passed by this court. In the case reported in 2009 within bracket 1 bracket close JCR 262, and has submitted that it has been held that there is no bar with respect to a widow to adopt a child and if her husband dies, to adopt a child, and in the present case also, no such prohibition in the custom amongst Santhal has been brought on record, debarring a Santhal woman from adopting a non-Santhal child. In response, the Learned Counsel for the appellant has submitted that the judgment relied upon by the respondents was in relation to adoption of a child from the community itself, from Santhal community itself. And so far as the present case is concerned, the adoption is from a community outside Santhal community, and therefore the state judgment does not apply to the facts and circumstances of this case. मुझे एक judgment बनाई थी।
रिवाइज पर जो है डिसीजन लविश्वर मंडी वाला
क्या नाम है? लवेश्वर
लविश्वर मंडी वर्सेस पुराण मंडी।
कौन सा जजमेंट है?
लविश्वर मंडी ये लिस्ट में था 2000 का वॉल्यूम 8 है ना।
उनका submission is on the point of Hinduized Santals. The learned council has referred to the judgment passed by the Honorable Supreme Court reported in 2008, bracket close 8 SCC 587, Laveshwar Manji versus Pran Manji and others. Yes, I bring them. Mr. योगा सबमिशंस तो लिखाए हैं. This appeal has been filed against the judgment dated 30/9/2002 within bracket decree signed on 3/10/2002 bracket close passed by learned district judge Dumka entitled appeal number 5 of 2001 confirming the judgment and decree. Judgment dated 5/1/2001 within bracket decree signed on 16/1/2001 passed by learned subordinate judge 1 Dumka entitled suit number 35 of 94. The learned trial court had dismissed the suit stop. The suit was filed challenging the registered deed of adoption dated 30/9/1994 executed by defendant number 4 on the ground of prevailing social customs amongst the scheduled tribe community, namely Santhal. As per the relationship between the plaintiffs and defendant number 4, a genealogical table was furnished indicating that the common ancestor was Dhani Tudu, who had two sons, namely Larha Tudu and Savan Tudu, and Lehra Tudu had also two sons, namely Karyo Tudu and Dhena Tudu, who were the plaintiffs number 1 and 2 in the suit. The other brother, namely Savan Tudu, had one son but had expired. The name of the son was Jatla Tudu, and defendant number 4 was the wife of Jatla Tudu, who had no male issue but a daughter, namely Alodi Tudu. Who was already married and was not a party to the suit. It was a case of the plaintiff that Alodi Tudu had married several times and under the influence of defendant number 1, she developed illicit relationship and then the defendant number 4 and the daughter Alodi Tudu were completely in his clutches, and the defendant number 1 got a deed of adoption created on 30/9/1994. Falsely and dishonestly. Adopting, by which the son of defendant number 1 was adopted by the defendant number 4 on 13/1/1994. The defendant number 2 is the wife of the defendant number 1, and defendant number 3 is the so-called adopted son and minor. The specific case of the plaintiff was that no adoption at all by performing any ritual or ceremony was done. It was further stated that there is no prevalent custom of adoption in Santal community, and the Santal community by any widow, that too of custom of adoption by a Santal to Dikku, within bracket non-Santal. Other points were also raised that that practically there was no transfer of defendant number 3 to the family of the defendant number 4, and that he was still living with his natural parents. The locus standi of the plaintiffs was explained by stating that according to customary law of Santals with regard to inheritance, the plaintiffs had the right to inherit the property in absence of any male, any son of defendant number 4, and therefore they had the locus to challenge the alleged deed of adoption. The defendants number 1, 2 and 4 had filed a common written statement and denied the existence of any customary law if applicable to the society of Santals with respect to succession, inheritance, marriage and adoption. It was asserted that there was a revolutionary change in the living style, culture amongst the Santals in the locality, and the Santals have adopted the lifestyle of Hindus in every sphere, followed by culture of Hinduism. It was also asserted that a Santal widow having no son under custom is entitled to take valid adoption of even a Hindu son of her choice. It was further stated that in the locality there was famous temple of Baba Basukinath, and the Santals of the locality used to worship Baba Basukinath with all religious sincerity, and the family of the plaintiffs as well as defendant number 4 were quite separated from each other since long. It was further asserted that the defendant number 4, the adopted son, and defendant number 3 were all living jointly in the house of defendant number 4. And they are in possession and occupation of the property of the husband of defendant number 4. The other allegations regarding character, etc., of the daughter of defendant number 4 were denied. It was also asserted that many persons of the locality, including the village Pradhan Govind Tuddu, who is none else but the own nephew of the plaintiffs, had also participated in this eve of adoption and local ceremony known as Nima Namdhari, meaning renaming the adopted boy, was also performed. It was asserted that a Santhal widow has a valid right of adoption. And there was no bar in adopting a Hindu boy, as the two societies were so intermingled with each other in the locality, and they jointly share the feelings together. The trial court was of the view that the following points are relevant. 1. Whether the defendant number 4 had the right to adopt. Number 2. Whether, if so, whether she has right to adopt a Hindu boy. Roman 3. Whether the plaintiffs have any locus standi, especially when the defendant number 4 has a living daughter. In bracket, of course, who has not been male party in the suit, made party in the suit. That it is. Yeah. Both the parties led oral and documentary evidences. The deed of adoption, the registered deed of adoption was Exhibit B. The learned trial court framed the following issues for consideration. The issue number 4 and 5 were taken up together. The learned trial court discussed the materials and recorded that there was clear-cut evidence that the village of the plaintiffs belonged to Santhal and densely populated with that of Hindu families. The learned court also recorded that the members of the family of plaintiff as well as defendant number 4 used to worship at the temple of Lord Shiva, commonly known as Baba Basupinath, and followed the puja of Hindu goddess. The defendant number 1 admitted the DW1 admitted in her evidence that she used to be guided by customs of Hindus. DW1 is defend number 4. The learned court ultimately recorded while referring to the law of inheritance and observed that the discussion of custom of Santhal as available in Gangster Settlement Report does not suggest that the widow of Santhal is lawfully restrained to adopt a boy, that too of a Hindu boy. Then the learned court went on to see as to whether the custom of adoption is available in the society of Santhals or not. The learned court observed that, as per the plaint, it was the specific case that there is no prevalent custom of adoption in Santhal community by any widow, and that too there is no custom of adoption of any Dikku by Santhal community. The learned court reiterated that there was no rule to show which restrains the system of adoption in Santhal community, and also referred to section 24 of the Santhal Pargana Tenancy within bracket Supplementary Provisions Act 1949, which specifically dealt with adoption among Santhal, and ultimately held that adoption in Santhal community is well recognized and prevalent, and held that the question that there is no prevalent custom of adoption in Santhal community does not stand true and correct. Then the learned trial court went on to consider as to whether there is no custom of adoption of any Dikku by any Santhal community. The learned court was of the view that since the plaintiff has challenged the propriety of adoption of Dikku by Santhal community, it was the plaintiff who was required to prove the same. And the learned court ultimately held that no rule can be formulated governing the choice of a person who desires to take a boy in adoption and the plaintiffs and it could not be gathered from the evidence of the plaintiff with regard to such exclusion. And that the desire and necessity of adoption depends upon the personal choice or selection of a boy. Thereafter, the learned court examined Exhibit B and observed that the aforesaid ceremony of Nimadhari were performed. The Learned Council has some name. The Learned Court observed that there was evidence that on the eve of adoption, the puja according to Hindu customs was also performed in presence of Pandit, and puja of Satyanarayan Katha was also observed. And considering the totality of the materials on record, it was of the view that both customs, through Santhal process as well as Hindu custom, were performed. And the court did not find anything wrong in performance of ceremony of both Hindu custom as well as Santhal custom. The court also observed that DW2, Govind Tudu, who was a member of the same family, had come up before the court to support the giving and taking of the defendant number 3 in adoption. And the ritual of adoption of defendant number 3 cannot be severed otherwise, only because DW3 reported that he had not seen any Santhal women taking a dippu in adoption. The Learned Court ultimately held that if the said witness DW3 had not experienced any Santhal women taking any child in adoption, that would not take the shape of a binding rule of the custom of adoption by Santhal women with respect to a child, much less if the child is Hindu. The Learned Court also recorded that merely because as per Santhal law of inheritance, a widow has every right a widow has not even right to create Gharjamai. That does not necessarily mean that she has no right to adopt a child, because the rule of inheritance does not guide the rule of adoption. The Learned Court observed that both the aspects are different and in operations and effect. The Learned Court ultimately came to the conclusion that there was no material to observe that a Santhal woman cannot adopt a child, much less a child of Hindu community. And also held that since the defendant number 4 herself is asserted to have exercised the right of rituals and customs of adoption, the court came to a definite conclusion that defendant number 3 is the adopted son of defendant number 4, and the adoption deed number 152 dated 30/9/1992 was declared to be valid and genuine, and the suit was dismissed. So far as the Learned First Appellate Court is concerned, the Learned First Appellate Court was of the opinion that the Exhibit B being a registered deed of adoption was of the opinion that defendant number 4 admittedly took defendant number 3 in adoption after death of her husband. She also admitted to have executed a deed of adoption, Exhibit B. Therefore, the deed of adoption, Exhibit B, cannot be said to be forged and fabricated. The only question which remained was whether the defendant number 4 was legally entitled to adopt the defendant number 3. The learned first appellate court considered the materials on record and was of the view that and recorded the finding in paragraph 17 as follows. And ultimately dismissed the suit. Para 17. So far as the first substantial question of law is concerned, the same essentially deals with Exhibit B. The perusal of Exhibit B revealed that the defendant number 4 stated that she did not have a child, and as per Hindu religion and also custom of Santhal, there is a custom of giving Mukhagni as last rites, and Shraddhakar, etc. is required to be performed, and for that a son is required, and that son is also required to carry forward the lineage of the family, and therefore she thought it proper to adopt a son, and after search she found the defendant number 3 suitable, and she performed the required ceremony. She invited her family members on 13/1/1994, which was a Thursday, and one Devta was worshipped as per Santhal custom, and Havan was also performed, and as per Santhal custom, Neel Damar was also performed, and there was handing over and taking over of the child. It was also mentioned in the deed that the child, once grows up and the defendant number 4 dies, he would perform the custom of Mukhagni, Shraddh, as per Santhal custom, and would also take care of the family of the agriculture of the family. This court finds that as per Exhibit B, she claimed herself to be following Hindu religion and also Santal and also governed by Santal custom, and referred to Mukhagni and Shadkan and also Havan and the purpose of the adoption was that for their forsake purposes a son is necessary. This court also finds that the learned courts have considered the recital of Exhibit B and also the evidence of the witnesses, particularly DW6 and DW3, who had also stated that on the eve of adoption, puja according to Hindu custom was performed in presence of Pandit, and Satyanarayan Katha was also observed. And the learned courts observed that as per the, on the basis of materials on record, that the customs in connection with Hindus as well as Santhal were performed at the time of adoption. This court is of the view that the Exhibit B on the one hand referred that the defendant number 4 was following Hindu religion and at the same time referred to Santhal customs. And there was enough evidence on record to show that the family of the family was performing puja and other rituals while worshipping Lord Shiva at Baba Basukinath temple. This evidence was supported by the evidence of the witness of the plaintiff also, PW3. The Exhibit B was not the isolated evidence which was taken into consideration to come to finding. Rather, Exhibit B was seen in the light of the other materials placed on record. And the learned court recorded a finding of fact that the defendant 4 was sufficiently Hinduized. This court is of the considered view that, irrespective of the fact whether defendant number 4 was to be governed by Hindu law or by Santhal customary law, the courts have arrived at finding that there was no legal bar amongst Santhal in adoption of a Hindu boy by a Santhal widow. And the alleged custom that adoption, if any, was confined only among Santhal and the boy has to be taken from Santhal community only, could not be proved by the plaintiff by quoted evidence. The plaintiff had also stated that there was no system of adoption among Santhal community. That plea was also rejected by the learned courts.
PW4 ही बोला है, PW4 के हमारे संथाल समाज में पुष्पुत्र होता है।
And the evidence of PW4 itself reflected that amongst the Santhal there is a system of adoption. In view of the aforesaid findings, that the adoption was duly proved as per law, irrespective of whether the defendant number 4 was governed by Hindu law or by customary law of Santhal. The second substantial question of law as to whether the provisions of Hindu Adoption and Maintenance Act 1956 would be applicable in case of adoption by scheduled tribe of a non-scheduled tribe does not arise for consideration. ये substantial question of law का क्या मतलब? Yes sir, second substantial question of law का तो कोई मतलब नहीं है क्या? Does not arise for consideration in this case. आपके submission में लिखते हैं that it does not arise for consideration. The learned counsel for the respondents has submitted that as per the judgment passed by the learned courts, there was no legal bar in adoption of a Hindu boy by a Santhal tribal, and therefore the substantial question of law does not arise for consideration in this case. That's all. Having answered the aforesaid substantial question of law in the aforesaid manner, this court finds no merit in this appeal, which is accordingly dismissed.